It would have been on.
Okay.
Well, good afternoon, and thank you for joining us while we're getting started here. Well, actually, thank you for joining us in our kitchen. It looks like we've recently moved to our new office here, and we're still trying to figure out the best way to lay out in terms of these Zoom meetings. So, but thank you for joining us today for this H2-Know. We're going to talk about a couple of pieces of legislation that we were successful, our legislative committee was successful in getting passed this year in the legislative session, and how that might affect some of our operations. And then we'll end with a few minutes from some of our friends from Nampa Meridian Irrigation District, just talking about some of their in-office best management practices. But first, we're going to turn the mic over to Bryce Ferris, who works with Sawtooth Law. He's going to talk to us a little bit about a piece of legislation this year that impacts irrigation districts and in particular, the tax deed process. So, Bryce, thank you for joining us. I would just another, I guess, point. This piece of legislation was brought to us and largely championed by our friends over at Nampa Meridian Irrigation District with Bryce's help, though it is something that I think irrigation districts throughout Idaho have thought about and wanted for a while. So thank you, Bryce. We'll turn the time over to you.
Okay, thanks. And can you guys see my screen? Yep, okay. So I'm gonna talk about the changes to the tax deed process that were approved this last legislative session and went into effect on July 1st. And the statute that you're looking at is the modified revised statute 43-1508 that went into effect July 1st. So I'm going to work a little bit backwards to give a little background of why we made the changes and what changes we made. So working backwards and looking at 43-1508, the prior version, and it's kind of hidden in the Title 43 statutes and the miscellaneous provisions, but was a statute that provided if a district acquired tax deed, then they basically obtained the same rights as a private purchaser. And it really didn't provide anything else. No process of how they would dispose of tax deeds, no process of notice to the owner or anything. So this, again, this is after they've acquired the tax deed for delinquent assessments under Chapter 7 of Title 43. So some of the districts were acquiring tax deed and disposing of properties just using that premise. They had the same rights as a private purchaser, still providing notice, going through an auction almost on their own without any statutory guidance or anything. And that had worked for a number of years. But there was a recent United States Supreme Court decision, Tyler versus Hennepin County, that came out and discussed when there is a tax sale by a county that if there's surplus proceeds, that it is an unlawful taking to retain those proceeds without having a process to provide notice and due process for the original property owner to claim those proceeds. So the situation would be something to the effect of taxes are owed, maybe let's $1,000 of taxes are owed. The property sells at an auction for $10,000. There's essentially an excess or surplus of $9,000. Well, without having some process to provide due process to the original owner of how they may claim those $9,000 excess proceeds, it was deemed by the United States Supreme Court to be an unlawful taking. So as that decision came out in May of last year, we started looking at this statute 43-1508, how we need to make some changes to incorporate a process for disposing of surplus property. As we went about that, we looked into other things like when properties are acquired by tax deed, maybe they're not even able to be sold, maybe because they're odd lot or they're remnant parcels or whatnot. Nobody's even buying them at the tax deed auction. So what could we do to address those? And also, what about parcels if they have the same rights as a private purchaser, what can a district do to retain the property themselves? That started another discussion because the current statutes provide a right of redemption for the original landowner up until the property sells. So if a district wanted to retain a piece of property, let's say it was along one of their canals and it was going to be something useful for them, essentially that right of redemption would continue on forever because there would be no sale. So as we start addressing the surplus and the Tyler versus Hennepin County case, we started looking at these statutes and providing some different options and clarity of what a district could do once they acquired tax deed with that property. So if you can see, this is the revised 43-1508, and you can see what I've highlighted. These are the three options that are now provided and available once tax deed is acquired. So there's obviously the right to lease, sell, retain the property, and remove the water from the property. This third one, remove the water from the property, came about in discussions about some of these properties where, again, it's remnant, not able to be sold. What can we do with it? If we don't sell it, there's going to be continuing assessments against that property, presumably in perpetuity. So is there a way to remove the water from the property altogether and at least stop the continued assessments going forward on the property? So I'm going to go through 43-1508, and then we're going to bounce back to the changes that were also made to provide more options to a district even before you take tax deed. So 43-1508, as you can see, and I'll work through it, provides a process for the district to sell property that they've acquired by tax deed, providing a notice, an opportunity. It's very similar to the initial taking of the tax deed. You can see the reference to 43-717. And then it also, to address this Tyler versus Hennepin County, it provided a process to dispose of if there are any proceeds, excess proceeds. They would then provide notice to whoever that original landowner was, and that there's these excess proceeds that are available, provide a process for that person to come in and make a claim to those. And if so, they would be then be sent to whoever that original purchase or original landowner was. If not, then the district could retain whatever those excess proceeds were. The next would be where I've got highlighted here, number 3, is the district decides that it doesn't want to sell the tax deed property. It wants to retain the property for its own use and benefit. Again, it's for some reason it's maybe along a canal and they'd like to see it, or it has some use for them for their own use and benefit. It gives them that option. But again, now there's a notice and a process to essentially cut off the right of redemption. So before 43-7-112 provided the right of redemption was up to the point it sells. Well, again, if you're retaining the property, you're not selling it, that right of the redemption would just continue on. So this is a process. If you do make such an election to retain the property, you're giving notice and you're providing a process to that original landowner to come in and provide notice so that you can say, I've decided to retain the property, and the right of redemption is then extinguished. The third option, and this is in number 5, which is the district could remove the water altogether. Again, this would come up where a district acquires tax deed because of unpaid assessments, but nobody wants to buy it. Nobody has any use for the property. Again, it's some island or odd lot that they can't dispose of it. So instead of just retaining that property in perpetuity and continuing to prolong the assessments, they can at minimum go through a process to remove the water and stop those assessments, put the water to use on other lands within the district or whatnot. And again, it's providing a process to provide notice to the original landowner that you're going to remove the water. So as you go through these three different options that were discussed post tax deed, there was also then discussion about, well, wait, before we even take tax deed, could we make some of these determinations? Could we remove the water, or could we decide not to take tax deed in the first place so that we don't end up with these properties? And that then boiled into some changes to 43.716. So again, I'm showing you the amended 43.716 that was the legislation and passed and became effective July 1st. Prior to this, the statute provided that if someone is delinquent for 3 years, then the district directs the secretary that they must take tax deed. So not all irrigation districts had been doing that, but if the literal reading of the statute was you must take tax deed, that was your only option on delinquent assessments. So if that's your only option, you're taking tax deed and then you're going into that new statute and dealing with, again, a situation sometimes where you would own the property and via tax deed and not be able to dispose of it. So there became a little bit of a discussion of why not give some options before you even must take tax deed. So that then turned into the changes to 43.716. And similar to the changes, again, this is pre-tax deed. This is as someone is delinquent for 3 years. And again, the prior statute said you must take tax deed. Now it's providing some options to a district to do some things different than just taking tax deed altogether. So if you follow my highlights, the district after 3 years of delinquency is vested with the discretion. It provides some factors for consideration. This is not an all-inclusive list. There could be other factors that the district could consider before it made an election of what process it's going to follow. But after that, the district then has the option of taking 3 options here. And item A here is to continue to just take tax deed, follow the process in compliance with 43.717, 43.718, and take a tax deed. So again, they provide notice. They go through those that have been taking tax deed and following the statute with the quote must provision. Business as usual. They will just continue to do what they've been doing as far as providing the notice, certified mailing, publish in the paper, try to contact the prior owner. Obviously, the ideal situation is try to get the assessments paid in the first place. But if not, then this is option 1, at least, to continue to take tax deed. Option 2 under B here is to remove water from the land. What this is doing is in situations where, after considering the factors listed up above or other factors, the district can, in its discretion, decide this property is, for whatever reason, not going to have any value. We don't think we're going to be able to want to retain it. We don't think we're going to be able to dispose of it through some sort of a sale. So we're going to remove the water before we even get to this tax deed process. We will essentially exclude the land from the district, and it provides for a process for the district to, again, you got to provide notice, you got to go through a process, but basically it's telling that landowner, you've been 3 years delinquent, we're not going to take tax deed to your property, but we're going to remove you from the water from the district, so the apportionment of benefits from the district. And it provides a process to do that. The idea would be is if, again, you can't sell it or recoup those assessments, because it does cancel the assessments, would be, again, at least you've removed the water. You're not perpetuating a future long-term assessment against lands that have no value and nobody's ever going to claim. And you can use that water on other lands and apportionment within the district. So that's option 2. Option 3 would be, and I think this is what some districts had been doing, is just continuing to assess the land, leaning the land, and waiting for the land to either sell, title company to reach out, and just continuing the assessment. So you know, again, depending on how you read the statute before, which said you must take tax deed, some districts had just been not taking tax deed, continuing to assess, levying future assessments and leaning the land. This gives that option. So basically it protects those that weren't taking tax deed and provides them with, okay, option 3, if that's what you want to do, you can continue to do it. And you could do a mixture of all 3 of these 3 options. You could say for some properties, for whatever reason, we've decided that it makes sense to just continue to assess the land. For whatever reason, we've decided this is a odd lot, whatnot, we're gonna remove the water right. Or for whatever reason, we're gonna continue to take tax deed. You can do all 3. Or you can continue on with whatever you're doing, but essentially it provides the 3 options prior to even taking a tax deed to make some decisions and options to address these delinquent assessments. The last statute that was changed, and it just was again, this is 43-712. Before, it provided a right of redemption and essentially said that the right of redemption for the original landowner was up until the time of the sale. It was revised just to correct that or modify that so that the right of redemption can be terminated. And it references 43-1508. So basically that if the district chose one of the options after tax deed to retain the property or remove the water right, it could have removed the right of redemption also. So 43-712 was changed quite a bit to add more specificity as to how that right of redemption occurs, but it really, for the most part, it was just making sure that if the district chose to retain the property and cut off the right of redemption, that was clearly provided in 43-712. So I know I went fast because I only had 20 minutes, but those were the changes and kind of how it came about. I think what it does now is it gives an irrigation district options both before taking tax deed, again, on 3 years delinquent assessments, to either take a tax deed, remove the water, or just continue assess, levy assessments and lien the property. And then after, if it does take tax deed, and or if they've taken tax deed in the past, it gives some options on what they can do with that tax deed, including addressing that US Supreme Court case on surplus proceeds and giving options to the district to retain the property, remove the water also, or sell the property, which is again what had been occurring a lot in the past is the tax deed sales would occur. And sometimes they would have proceeds and we'd have to deal with that. Now there's a clear process to provide for that. So I think I'm close to my 20 minutes. I don't know, Paul, if you want to have questions or anything as each presenter, or do you want to do it at the end?
Well, maybe while we're on this topic, if there's a question or two, and I'll give you a moment to think about it. If you do, just raise your hand in Zoom and we'll get you. But I just reiterate that we were fortunate and appreciate having this bill pass. We did have, some concerns to early drafts raised by some of the banks and credit unions regarding their interests and how their interests might be impacted by one path or the other that may be chosen, ultimately able to get those things resolved. And as I will say with the next one as well, very appreciative of folks like Bryce and Michael and others who were at the front edge of this, helping with this, and then the legislative committee who stayed abreast and asked all the really good questions. The only other thing I would say would be this, while it is much, I think, more appealing and much preferred to the old process, it still is a process. There are timelines that have to be met, notices that have to be given. And when you're dealing with property and money, those things and those requirements and the importance of that is just heightened. So as you go through these processes, urge you to make sure to really thoroughly read these code sections, talk to your legal counsel, and make sure that you are following those processes as outlined in the code. If concerns arise or disputes arise after the fact, that's what you have to point to. That's what you will point to in terms of protecting the district, is making sure you followed those processes, making sure you did the things as outlined in the code. But thank you very much, Bryce. I don't see any hands. Are there any questions?
Paul, this is Dan. I think I'll follow up a little bit on what Bryce has discussed. You and I and Bryce have also discussed the need to take a look at Chapter 7, the Title 43 Irrigation District Assessment Statutes, and see if we can't bring them up to date more as a whole. And make them easier to utilize. So if I may share.
Yep.
With the passage of the bill that Bryce prepared, Nampa Irrigation District has been working through how to implement the statute's new provisions. And so we have prepared an assessment guide, which I'll share here now. And this is like one that I prepared like 25 years ago, believe it or 25 or more years ago, and one like the one you prepared, Paul, some time ago, which outlines important terms in the assessment, redemption, and tax deed issuance process, and then goes through the calendar of actions that the district takes along the way, from determining and levying the assessment to collecting the assessments and identifying delinquencies and then taking action with respect to delinquencies. And then includes the options that Bryce has discussed. And in addition to preparing this guide, we've developed criteria to help the district make the decision about which of the options that Bryce mentioned that the district now has available to us, whether to pursue the issuance of a tax deed, remove the water right, continue to assess. And in doing this, going through this process, we've identified terms and procedures that still need to be updated in Chapter 7 with regard to this assessment, redemption, and tax deed issuance process. So the district has authorized me to go ahead, Paul, and work with you and other irrigation district attorneys in updating Chapter 7, and doing so this year. And we've discussed this before, and the district has decided to go forward with that work. So what I would intend to do is to, if people are interested, share this assessment guide and identify amendments that we could consider making to Chapter 7 to be discussed, likely amongst a work group, specifically irrigation district managers and attorneys that work with the assessment, redemption, and tax deed issuance process, to develop legislation for this upcoming session.
Thank you. And I think, Dan, what I'll do, maybe you and I over the next week or so can start, put together an email that we can send out to irrigation district secretaries and managers and attorneys to start that discussion process. And then we will have our first legislative committee meeting sometime in the next couple of months. Barney and I will get together and get that date figured out to folks, and we can then form a work group to get this going.
Sounds good.
So not seeing any other questions, we'll move on to the second topic, another piece of legislation involving easements and ditch easements. And, you know, we over the years have had a lot of amendments, bits and pieces of the code have been amended, and it has resulted in some confusion and some other issues that a work group of the legislative committee spent much of the last year working on an effort to try and clean up some of that. And Dan was really one of the, if not the primary driving force behind a lot of the work that was done. Really a lot of heavy lifting in terms of helping to align codes, make sure they were now clear and consistent with the intent and the practices of the utilization of ditch easements. As with the other one, there were concerns raised by some local communities and how these changes would impact existing infrastructure. Think power, city water, fiber, those kinds of things. And so a number of side conversations and meetings to get to a point where we were able to get a piece of legislation that made its way through the legislature. So Dan is going to talk to us a little bit about that. You're up, Dan.
Okay, and this bill, like so many others, and like with the Chapter 7, Title 43 assessment statutes we just discussed, highlights the importance of statutory language and consistency in statutory language. And these easement statutes in chapters 11 and 12 of Title 42, many of them date back, most of them seem to date back to 1880 and have been amended over the last 140 years to identify issues as they have arisen, many of which reach the courts. And then decisions are made based on the statutory language as it's evolved over time. But when piecemeal changes are made to statutes, and particularly within whole chapters that deal with a particular subject, inconsistencies can arise over time in terms of the language that is used at the time the change is made or the time the statute is enacted. And that was the situation that the court faced in a recent Idaho Supreme Court case, Hood versus Portman, where in that case, the court found that the statutes that address relocation and piping of ditches by servient landowners, court found that the statutes that deal with that type of modification to ditches does not provide for what we call a right of self-help, whereas statutes dealing with encroachments in the very same chapters do provide a right of self-help, where if someone were to put a fence or a structure within an easement right-of-way and refuses to remove it, and it's causing interference with ditch operation and maintenance, the ditch owner has a right to remove the obstruction to continue their operation maintenance activities. Whereas the court found that there is no such right when a landowner might relocate or pipe a ditch. Obviously, a type of modification that can have a much greater impact on ditch use, operation, and maintenance. And so that was the impetus for this legislation. And in taking a look at the language and figuring out how to revise, how to incorporate the self-help right for unauthorized ditch relocation and piping, that required looking at really all of the statutes within chapters 11 and 12 to make sure the language that we incorporate in 2024 is consistent. So I'll share a screen to outline what we did. So this is a quick look at the before and after. Before, these two chapters of Title 43 consisted of 16 separate statutes And with the revisions that we made, they now consist of 9. The legislature repealed statutes that are antiquated and haven't been used in anyone's experience. We consolidated statutes so that the same subject matter would be dealt with within the context of fewer statutes, such as a ditch owner's operation and maintenance duties. In the statement of purpose for the bill summarizes what was done. The 5th item here is the revision that I'll show you to address the Hood versus Poorman case to ensure that ditch owners have the right of self-help with respect to unauthorized ditch relocation and piping. Other changes that were made were to ensure that all types of ditches are covered by these statutes, not just canals, which or ditches, which might be referenced here and there, but canals, ditches, laterals, and drains. So there would be no confusion in the future about the types of facilities that these statutes apply to. We clarified the circumstances in which a landowner has notice of a ditch right-of-way. I'll show you that. As I mentioned, we consolidated ditch operation and maintenance duties into 1 statute rather than 5. And as I mentioned, the legislature repealed antiquated provisions. The key provision is the one on the left-hand page here relating to the right of self-help with regard to unauthorized encroachment, relocation, and piping. And now, as a consequence of this legislation, the same language is used in each statute that deals with unauthorized encroachments, relocation, and piping. And the statutes, these statutes now provide that encroachments that are placed without the express written permission of the owner or operator shall be removed at the expense of the person causing the encroachment or permitting the encroachment in the event that that encroachment causes material or unreasonable interference with the use of the ditch and the right-of-way. And the process that is outlined in the statutes is the process that the court has described in several cases, Pioneer versus Caldwell being one of them. The process then is that the person causing the unauthorized encroachment is to remove it, modify it, repair it and or the ditch, restore the ditch within a reasonable time after request from the ditch owner or operator to do so. What constitutes a reasonable time depends on the circumstances affecting the use and operation of the ditch. That's the deference should be given to the ditch owner to determine how much time is really required in the case of an emergency, where to address the emergency, you can't wait for a response, then immediate action can be taken. But where there's a non-emergent circumstance, the period of time you can give the encroacher or the piper or the ditch relocator to remedy the situation should be consistent with the time needed to get the ditch back in functioning order or to remove the encroachment that's preventing O&M. Then if the person or the entity that caused the encroachment fails to act within that time, as you can see in section B here, the owner or operator of the ditch has the right to remedy the situation, and the person causing the encroachment is responsible for the cost of the remedy. So now there should be no question about, number one, the right of self-help with regard to encroachments, ditch relocation and piping, and the process for initiating and accomplishing the remedy, either by the landowner, or if the landowner won't do it, then by the ditch owner. Okay, and I'll breeze through other changes to the statute that I think are notable. these two chapters, 11 and 12 of Title 42. 11 deals with the entitlement to a ditch right-of-way for a ditch and the rights that a ditch owner has in operating and maintaining the ditch, and the written permission requirement for modifying the ditch. Chapter 12 has to do principally with a ditch owner's obligations to operate and maintain the ditch. And as you can see, as I've outlined here in 1102, subsections 1 and 2 provide for the entitlement to the ditch right-of-way and describe the rights. Now, when in preparing this legislation and reflecting on litigation that's arisen or questions that have arisen over time, courts and people have wanted to know what is the source of these rights and obligations and these entitlements. So one of the tools that we prepared in pursuing this legislation is an old school summary of points and authorities of cases that support the provisions of the statute. And Paul, I'd be happy to provide you that summary of points and authorities for people's use as these statutes are applied going forward. One of the things we did, in addition to addressing the Hood versus Poorman case, was we clarified the notice that a landowner has of the existence of a ditch right-of-way. What the statute had provided previously was basically where a ditch is visible, can be seen on the property, physically, visually observed, then that provides notice to the landowner. But a question arose as we were working on this legislation within the work group: what about a buried ditch? What about a pipe ditch? One that's not easily visible. So we modified the statute to provide that the landowner has notice of a ditch right-of-way where they have actual or constructive notice. Those are legal terms that are well defined in the case law. Or the presence of the ditch, if it's a pipe ditch, is reasonably discoverable by, for example, examining a plat or other document in the chain of title or other available document. So in addition to visually, physically apparent ditch right-of-ways, ditches, and irrigation conveyances, the statute now provides that the landowner has notice of the right-of-way where, although it may not be visible, its existence is discoverable through records pertaining to the property. As I mentioned, outlining here, Chapter 11 now has the provision that I've summarized previously for remedy when written permission is not obtained for an unauthorized encroachment. We also clarified the right-of-way for a diversion. I think we'd all assumed that that was clear in the case law and in common experience and in the statutes, but it wasn't as clear as it could be. So we clarified in 42-1105 that a water right owner, a ditch operator, a ditch owner has the right of way to construct, operate, and maintain a diversion to divert water from the natural source to convey water through a ditch system. Let's see here. Then finally, there are other details we could go through, but I think these are basically the highlights. There's the criminal statute with which I'm sure you're all familiar that provides that had repeated the language of 42-1207 pertaining to unauthorized relocation and piping of statutes. So what we did in 4308 is we removed the lengthy repetition and we referred to 1207 to define the misdemeanor. So any person who relocates or pipes a ditch places it in pipe, culvert, or other conduit, contrary to the provision of 42-1207, is guilty of a misdemeanor. So you refer back to 1207 to see what 1207 provides and requires with respect to ditch piping and relocation, determine whether the conduct may rise to the level of a misdemeanor. With that, Paul, I'd be happy to answer any questions.
Thank you very much, Dan. Again, a lot of work went into cleaning up, aligning, making sure that the language fit with what the practices and the case law has allowed over time. And so again, appreciate Dan and the other members of that legislative committee. There was and the work group. A lot of work went into this. Any questions for Dan on this legislation? All right, well, thank you very much, Dan. I appreciate, again, your time, and thank you, Bryce, as well. So switching over to Catherine, who will introduce our last two presenters.
So for our last presentation, we have Connie Keys and Debbie Rubel from the Nampa and Meridian Irrigation District. They do the internal processes for the tax deed process. And so they are going to talk about some best practices and how to do what needs to be done.
Okay. Hi, everyone. I'm Debbie. I'm the assistant treasurer here at the district. Connie is our resident tax deed expert. She does it all, knows it all. So we're just going to kind of step you through the process that we do. We're going to be talking about both the pending tax deed year and the tax deed year, because a lot of the work happens in that pending year. So we'll go ahead and share our screen. There we go. Okay, you're all seeing it? Okay. So can you
couple little tweaks.
We're seeing the presenter screen. Just switch the screen that you're sharing to the presentation mode, or to the presentation one.
We're working on it. Just a second.
We're having some technical difficulties.
Let's do this. Is that over, Paul?
It's still doing the same thing, but that's okay. We'll just read what you're presenting, and we'll know what's coming up.
Okay.
Okay. So a couple things to keep in mind when you're doing the pending tax deed and tax deed processes. Go back one screen if we can.
Oops.
Two screens right there.
There we go.
First and foremost, on any of this, you want to be sure and track any of your expenses. And we're talking about prepping of files, the employee time, the publishing costs, anything that we do on those tax deed or pending tax deed properties. We keep a ledger of those costs, so to speak, and then we add those to the delinquent accounts. And so those costs are somewhat recovered, so to speak, when the assessments are paid. So in any of that, we keep copies of any letters we send, any correspondence, any emails. We also make a brief synopsis of any of the conversations, who we've talked to, what dates and what they say. This is pretty nice to have if it ever goes to court in any kind of a lawsuit or anything. We've got documentation, a whole bunch of documentation. So we've got copies of anything we say, and anything we've sent or anything we've talked to. So we've the actual timeline, your property becomes a pending tax deed on that third year of delinquency. We had 793 properties go pending tax deed. But before you go, oh my gosh, that's a whole bunch, it really was only 1.7% of our total assessments. So it really was pretty amazing this year. Every pending tax deed gets a folder, and we create a couple of different items to go in that folder. The next one we'll show you is a log sheet that we've made. What's nice is that keeps us on track for different things that need to go chronologically into those folders, starting with the worksheets down into the letters we send, the certifieds. It kind of keeps us on track of dates and times and when we have to do things, certain things that are required by Idaho code, and certain things we do that aren't, that we just go above and beyond to try and collect. Our planning department also proofs all the legal descriptions of any of our pending tax deed. We want to make sure that we have a accurate legal description. If we have filed liens on incorrect legal descriptions, we have to correct those and do a corrected lien with the counties. And those corrected liens really have to be done before we ever take a tax deed. We also do some county research by stepping in or us accessing the Ada County or the Canyon County property taxes. A lot of times the county assessors are aware of mailing address change or deeded owner change long before we are. Sometimes the title companies don't always remember that there's an irrigation tax to change with deeds. So into May, when they're in the preliminary stage still, we send out a preliminary tax deed notification. It's just a letter to the property owner describing, hey, just so you know, your property's 3 years past due. It'll be going tax deed at the end of the year. It's really, really effective in letting the property owners know that there's an issue. And so we get a lot of them collected off of this preliminary. It's not required by law, but it's something that we do just to alert the property owner. The first thing we have to do that's actually in the state code is we have to send a notice of pending issuance of tax deed. It is the first item required by law. It's a certified letter that we mail out. It goes out no more than 5 months before we actually issue the tax deed. And it's got certain vital things that we have to send into that letter. And so it's got, and it goes by A, B, C, D in our letter that we send, but it also follows state code as to last known deeded owner information, the property, the dates they were delinquent, the amount due, when the tax deed will issue, et cetera, et cetera. So that's our first thing that we send out certified. Any property, when we send out the certifieds, we get a notice back that they've signed or acknowledged that they have that, that they've signed for it and they have received that letter. And so that's our due diligence in getting that to them. If they don't sign for it, if it comes back unclaimed or rejected or refused, then we're required by state code again to publish information now in the newspaper. And so that basically is now showing that it's our due diligence to try and notify them again that their property is going to go tax deed. The ad that we publish goes in into the local newspaper. If it's a Canyon County, it'd be the Idaho Press Tribune, or Ada County, to the Idaho Statesman. But that ad publishes once a week for 4 consecutive weeks. We generally do that in November. And then the cost of the ad, depending on how many properties we're publishing, those costs get actually added into the assessment as well. So what we're showing on the screen is a copy of a couple of different ads. It's vital that you get an affidavit of publication from the newspaper. That way, if it ever goes to court, they can verify by that affidavit that it actually was published in the newspaper and that those costs, were actually legitimate costs of what we're adding to the homeowners. The one on the left, for example, was a Canyon County one, and it was over $1,000 for the legal notice. And unfortunately, with him being the only property, it had to get added on to his bill. The final notice that we issue out is in November. Again, this is not required by law, but it's kind of another preliminary like the one in May. We send that out to let them know that, hey, we've got to the end of December to get this paid or it's going to go tax deed. Again, we want to keep those copies of any of those letters that we send out as well. Towards the end of the year, we do an affidavit of compliance. It basically affirms that the district has followed Idaho code in order to take that tax deed property, certified as a tax deed. It shows or verifies that we sent out a certified mailing, that if they were undelivered, the code reads that we look up their phone number in the phone book, but we also do other online resources to find phone numbers. And it also certifies that we're compliant for any undelivered notices, that we publish that information in the newspaper. And again, a copy of that goes in the file. That's a similar one. And then all of a sudden it's January again, and now we're a tax deed process. So on January 2nd, after the 4th year of delinquency, the tax deed is issued. We had 32 properties go tax deed this year, which was 0.071 of our total assessments. And happy to say that all 32 of those properties are paid now, so there's nothing going to auction. As we start the tax deed process, we make more additions to our folder. And again, a full assessment report and different things are gone into the file. Throughout the next few months, when they're tax deed, we send out what we call a courtesy notice. It's basically a nice formal letter stating again what's going on, and that we have taken tax deed to the property, and we try and emphasize why it's so vital to get those things paid. As the tax deed properties are paid, we process what's called a redemption deed, because remember, in January we've taken tax deed, we've actually taken deed to the property. When the property is paid now, we process a redemption deed for the owner, and then we record it with the appropriate county. And this basically redeems the property back into the homeowner's name. If the property is still unpaid, we actually send out another certified notification of the tax deed auction. This notice is required by law, and this letter will actually state when the auction date is up and coming, the dates that the legal notice will be published in the local newspaper, and the amount due before the legal notice. So this letter, for example, gave the homeowner an amount through the end of July, and then letting him know that if it wasn't paid by the end of July, then it would be published in the paper, and then those legal costs would be added to the account after July 31st. Our legal notice, then we publish in the paper. These are a couple properties from a couple years ago. Again, is published in the corresponding county newspaper. It needs to run 3 consecutive days, with the last day of publication being 10 days before the date of the auction. So if it was this year, for example, we'd run the ad August 7th, 8th, and 9th, and our auction would have been August 20th. And that does comply with the time frame we need. After the legal notice, as a last ditch effort to collect, and what we've done is our district secretary, treasurer, and the water superintendent, for example, actually go out and knock on doors and hand deliver the notices. Again, it's not required by law, but it's something that we've done, and just as a last ditch effort to try and notify the deeded owners and to let them know how important it really is to get these paid. In our district, the tax deed auction is held the second board meeting of August. The amount required to redeem basically is all the taxes and fees that have incurred up to that point. Our tax deed auction is a sealed closed bid auction, and anybody that wants to bid has to come to the office at 5 o'clock the day before the auction and bring their sealed bid and guaranteed funds. The property owner actually has until auction time on the day of the auction to bring it in, and again has to have guaranteed funds to redeem the property and avoid it going to auction. If the property does sell at auction, it's generally your highest sealed bid wins. That's according or up to our board of directors. Then we process another deed to the new owner. It releases our tax deed and places the deed into the new owner's name. We record it with the county, and then it moves on. If the property doesn't sell, it's retained by the district. And that is a quick rundown, right? That was
Very quick.
That was quick. I had, it's a huge process that we do over those 2 years. We work it very hard. We're pretty excited about the new laws and the new changes coming up to maybe make our lives a little easier. And if you have any questions, give us a call.
Feel free to give us a call or email us.
Thank you. That was wonderful. That was quick and dirty.
Any
We
questions?
had 10 minutes.
Oh. I remember in my prior life working, representing an irrigation district, Burley Irrigation District, and just the effort they went through each year to not have to take a tax deed, visits to the door and emails and letters and phone calls. And I think I agree with you that the processes and the options allowed now under the new code, as Bryce was describing it earlier, will be a welcome relief for some of these processes. So any questions on this or any of our topics from the day?
Hear me? This is Anita.
Hi, Anita.
Hello. don't know what I'm doing, but I guess we're a little bit confused on the redemption deed. I'm talking with Sherry.
No, just if we take the property or if we took the water,
Okay, we were under the understanding that I think if we took the property or we took the water, there would be a year of time frame to sit on it for them to be able to get it back. But something that was said earlier made us think that when this new rule that we didn't have to do that. Does that-
Bryce, you want to pull up that code section? So yeah, the redemption timelines depends on the process or the path that is chosen by the district. Bryce, maybe you can walk through that briefly, but again, we could spend all day digging into the specific words of this. When that time comes to apply these, read them closely and give your attorney a call.
Okay,
Yeah, the short answer is if you elect, and I assume you're talking about after tax deed has been taken. If you elect to retain the property or remove the water, you are going to provide a notice, and that's what I've got here. You're going to provide a notice, and it directs you back to essentially following the same process you would take when you take tax deed, which is try to get them certified letter. If that doesn't help work, then you're going to publish in the paper. But basically, you're going to provide that property owner notice of what you've elected to do and gives them a time frame to come forward to redeem the property, claim the property before you decide you're going to retain it, or you end up retaining it, or you remove the water right. And that would cut off the right of redemption because, as I mentioned before, the prior statute 43-712 simply said that obviously they had a right to redeem up to the point it's sold. So if you were going to sell the property at tax deed, and as Connie and Debbie were going through their process, they have their auction in the second meeting in August. That would end that right if it's sold to someone. But if you didn't sell it, you did one of these other options. How do you cut off that right of redemption? Well, you go through these processes that are provided now in 43-1508 to give that property owner notice that you're going to retain it or remove the water. And so now you do that, and then you cut off the right of redemption.
okay.
So hopefully that answered your question.
I think so. I mean, we're just all learning here. So it'll take us a while. We've not done this process in a very long time. So, and on this conference call or this Zoom meeting, is there a way that we'll be able to get this like our boss he was drawn away and he really wanted to see the part on the ditch stuff. Can he get this and watch it?
Absolutely. We're recording this and Catherine will get it uploaded to YouTube and Taylor will include it in next week's email.
Okay, perfect. That'll be good.
Dan, there's a question in the comments. I'm particularly interested about the part of your presentation about filling in a ditch or altering the pipe now being a misdemeanor. Does that include altering the flow of an open ditch? This is from, who is that from? My Tana Boyd over at King Hill. Thank you.
No, that statute does not address anything other than relocating or piping a ditch.
I would also add it's the same. We didn't actually change that code section. What it historically had was essentially a copy and paste of what was in 42-1207. So it was a whole lot of words to say this is a misdemeanor. And so really the change we made was by pulling out all of the other language instead of copying and pasting it and just adding the reference to 42-1207.
Yeah, the other thing I would add would be that the existing criminal statutes in Title 18, Chapter 43 are still there, including wrongful diversion and those they weren't modified by this by these legislative changes. So that criminal statute that Dan was referring to is the one that was addressing piping, 42-1207. But the other criminal statutes are still there and had not been modified by these legislative changes.
Any other questions?
Yeah, Paul, I can I can send you the before and after and the outline of the changes to the easement statutes. I think that would be helpful to people. There's also your talking point summary that you used during the legislative session. I'll send you all of those tools we developed. Some are all of which I think you included in the materials you presented to the House committee. Yeah.
Yeah.
And then as to the assessment process, the assessment, redemption, tax deed issuance process, you know, if NAMPA Meridian would allow, I'd be happy to share the assessment guide once we have it fine-tuned to outline the entire process. It's a little easier reading than the statutes, to be sure.
Well, I'm not hearing any questions. Oh, one new message. Let's see here. Okay. Thank you, Kelly. We will include that also in Monday's email, kind of a summary, the video link, and then some of these resources that have been prepared. So any additional questions? Not hearing any, we will let you go back to your days. Thank you so very much for joining us. Thank you, Dan and Bryce and Debbie and Connie for helping us out today. Really appreciate you, and we'll talk to you later. Have a great day.